welcome to Litigation Help. My name is Heather, and joining me here in this video is Dan Rosman. So Dan, I want to ask you a few questions about lawsuits, civil lawsuits. I know that there are some overarching sort of basic phases or steps that are common to most lawsuits. Can you take us through those basic major steps in a lawsuit?
Sure. So in a civil litigation claim in Ontario, it starts at the pleading stage. So that means the plaintiff is the person that's bringing the case, the one that has a complaint that wants a judge to resolve. The plaintiff will issue a statement of claim, right? I mean, there are other times where they'll start with a notice of action and some other intricacies there, but just for general purposes, they'll start with a statement of claim. The statement of claim is going to tell anyone who reads it, specifically the judge, what the case is about, what the basic facts are, and the law that the plaintiff is relying on. The defendant will then read that and then issue a statement of defense. The statement of defense will tell their side of the story and raise any defenses that they think they need to raise. Now, there's some more pleadings that will go on with that. There could be replies, there could be motions in the pleading stage. But the pleading stage is basically putting both parties on notice, laying out the case for a judge as to how this thing is going to move forward. Right.
Okay.
So that's stage one, is the pleading stage.
Okay.
After that, you're going to move on to the discovery stage. In the discovery stage, both parties get to interview each other, they get to feel each other out about the nature of the case, the facts, what they have to do to win, and what's actually going to happen at trial. What are people going to say? What are people going to talk about? So the first step in the discovery stage is to exchange documents. So in a document exchange, it's usually called an Affidavit of Documents. The parties swear that all the documents in their possession are handed over to the other side. And then they can meet and they can ask questions to each other about those documents. Everything that they ask is transcribed and can be brought to trial later. After the discovery stage, then you get ready for trial. In Toronto, there's a mandatory mediation that must take place, in some other jurisdictions as well. There's probably going to be some procedural motions, which means going to the judge and asking for schedules and ordering deadlines, things of that nature. But we're pretty much after discovery, we're getting ready for trial, and the trial is the trial. After that, the case is over, hopefully.
What about enforcement? Is that something separate, or?
So enforcement is something separate because, you hope that if someone loses the case, they'll follow the judge's order and they'll do what they have to do or pay what they have to pay. If they don't, enforcement is a separate matter where you use the courts to actually go and take what the court says is yours.
Okay, so the court doesn't, if you win, the court doesn't automatically get the loser.
Well, it depends. I mean, the courts do a lot of different things. There's a lot of different cases that a court can hear, right?
Right.
So if a court says you lost, you have to pay $100,000 or $1 million or whatever it is, they're going to sign. You're going to get an order that says you have to pay $1 million. Yeah. Now, hopefully, that the losing party will write a check. Right. And it's over. Right. But if they don't, enforcement, you can take your order to the court and have, let's say, their house transferred over to you so that you can get your money, or look at their bank accounts, or garnish their wages. So enforcement is a separate step, and it comes after a trial or after a disposition of a case in different ways, such as a summary judgment or a default or something like that.
Let's say that you lost and you don't want the other side to come chasing after you just yet because you think that the judge was wrong and you want to appeal.
Right.
So can you?
Yes. So it depends. I mean, appeals are usually available, but there's times where they aren't, and there's times where they're only available in very specific areas, right? So a mistake that a lot of people make, some lawyers as well, not just self-reps, is that they lost, they're upset about their loss, so they want to do it all over again at an appeal court, right? And that's not how appeals work in Ontario. Appeals are very narrow. You can only appeal really if a judge made an error, right?
Right.
An appeal court is not going to listen to your testimony again. It's not going to look at the evidence again. But if the law says, breach of contract means that this and that happens, if the judge didn't apply that law correctly, an appeal court will look at that. But appeal court's not going to look at, did the judge didn't believe me and he should have, or the judge didn't like this document as much as he should have or she should have.
Yeah.
So that's a mistake that a lot of people do make with appeals. But in our other video, we talked about the rules of civil procedure, and that'll tell you what appeal is available to you from what court. A statute also, depending on what your case is about, will tell you what appeal is available to you and to what court you're supposed to go to as well.
Oh, interesting. There's also one point I want to bring up, which is the privacy of lawsuits. Now, I know that that trials obviously are open to the public, in general anyway, I would say. But now some of these things, I remember in the very beginning, you talked about pleadings. With those documents, once you file them in court, are those open to the public?
Yes. So the adjudicative process in Ontario, the court system is open. There's an ingrained principle called the open court principle, and in that principle, everything is public. So if you want to go to court right now and just read people's statements of claim or their defenses or whatever, you can do that. You can photocopy them. You can take them home. It's yours. They're public, right?
Right.
Someone can go and sit in your trial and watch. That's how it is.
But what if there's a minor involved and I want to protect their identity and things like that? Isn't there a way that I can...
Yeah, so there are ways, and those will also be found in certain statutes or in the rules of civil procedure, that you can ask a judge, and you'd have to convince that judge that this is a very important situation and there's very specific factors at play that needs to maintain a certain level of privacy, and the judge may grant that. Usually, when there's a minor involved, those are good reasons and things.
Right.
But usually if it's, this is an embarrassing lawsuit and I don't want people to know about it, won't keep it private.
Oh, darn. Okay. Well, Dan, Dan, thanks very much for all these tips. And thanks for watching. See you soon.